After the judges introduce themselves, we'll have you introduce yourselves to the judges, and then we'll get started. So I will turn the time over to the judges. Take it away.
Thank you. Welcome this morning. Congratulations for being here. And my name is Rita McCannon. I'm a lawyer in Huntsville, Alabama. And I will let my colleagues introduce themselves, and then we'd love to hear from you and who your teacher is. Tim?
Hi, I'm Tim Moore from the University of Wisconsin in Madison at the Center for the Study of the American Constitution.
I'm Jack Barlow. I am a professor of politics at Juniata College in Pennsylvania. Are you guys actually in Washington or are you in DC?
We're in DC.
In DC, okay. All right, so we're all on Eastern time then.
Is that me?
Except Nancy. Are you on Central, Rita?
Oh, yeah.
Oh, sorry. All right.
You have to tell me what time to be here, and you have to tell me in my time. Yours. All right. I assume we're all on Unit 2 because that's what I was told to do. And we have decided on question 2 for today. So I'm going to read that to you and then we'll get going. And I'm jealous that you're up there where we'd all like to be. Question 2. When explaining why the proposed Constitution lacked a Bill of Rights, one Federalist claimed that in a government possessed of enumerated powers, such a measure would not only be unnecessary, but preposterous and dangerous. Do you agree or disagree with this statement? Why or why not? In your opinion, did the first 10 amendments to the Constitution sufficiently address the concerns of the Anti-Federalists? To what extent, if any, should we consider adding additional amendments to our Constitution? We look forward to hearing from you, and you may begin.
We must never forget it is a Constitution we are expounding, intended to endure for ages to come. Chief Justice John Marshall.
We disagree with the statement that the Bill of Rights is unnecessary, preposterous, and dangerous. Rather, the Bill of Rights protects liberty by setting a standard for certain values that the federal government cannot contravene. Inspired by the English Bill of Rights of 1689, Anti-Federalists asserted that a Bill of Rights was necessary to protect the individual rights of the people, as the writer in Oldwig stated in his 4th essay.
Many desired rights were those believed to be violated by the British, such as the 3rd and 4th Amendments, which banned the quartering of soldiers and unwarranted search and seizures, respectively.
While the intent of the Bill of Rights is to protect the people, Alexander Hamilton in Federalist 84 argued that as all rights cannot feasibly be listed, a written Bill of Rights would then allow Congress to infringe on any of those unlisted rights. The 9th and 10th Amendments defend against this prediction by granting the people and states all rights not given to the federal government, thereby limiting federal power.
Ultimately, Federalist agreement to George Mason's proposal of a Bill of Rights was crucial in the ratification of the newly made Constitution by all 13 states.
The first 10 amendments to the Constitution did address some anti-federalist concerns by securing the rights of the people and states, but did not achieve the ultimate anti-federalist goal of restructuring the balance of federalism.
At the time of writing, the Bill of Rights protected essential liberties from federal infringement, as the Anti-Federalist George Mason proposed at the Philadelphia Convention and was later affirmed in the 1833 ruling of Barron v. Baltimore. However, the 1897 ruling of Chicago, Burlington, and Quincy Railroad Company v. Chicago first employed the selective incorporation doctrine, applying the Bill of Rights to state governments under the Due Process Clause of the 14th Amendment, and thus infringing on the state's sovereignty to set their own restrictions, a power noted in Brutus I.
A goal of the Anti-Federalist Bill of Rights was to prevent federal domination of the states by structurally changing the newly ratified Constitution. For example, Anti-Federalists at the Massachusetts Ratified Convention on February 7, 1788, proposed amendments that would limit federal power. For example, an amendment proposed was one that would limit Congress's ability to tax and spend in Article 1, Section 8, Clause 1, as well as an amendment that would limit Congress's ability to regulate elections in Article 1, Section 4. Despite these anti-federalist wishes, James Madison's proposed amendments were rights-focused and ultimately ratified by a Federalist Congress.
In his 6th essay, Brutus voiced fears of federal tyranny through Article 1, Section 8, Clause 12, which allows Congress to raise standing armies. James Madison weakly acknowledged these fears by proposing the Second Amendment, allowing states to raise militias against an oppressive army. While Anti-Federalists succeeded in adding a Bill of Rights to the Constitution, their plan to use this Bill of Rights to curb the balance of power within the new government failed to come to fruition.
We should consider adding additional amendments to our Constitution where rights regarding privacy and liberty are not fully protected. Although the right to privacy was upheld in Griswold v. Connecticut as a penumbral right under the 1st, 3rd, 4th, 9th, and 14th Amendments, it is not specifically enumerated on a federal level, thereby directly leading to infringements such as the 2001 Patriot Act. A right to privacy based on current judicial precedent would also protect the right to medical freedom.
Roe v. Wade expanded the implied right to privacy in regards to medical freedom by providing a federal precedent for abortion. However, due to the lack of a federal standard for privacy at large, other rulings, such as Jacobson v. Massachusetts in 1905, have left ambiguous the implied right to medical freedom. In addition to securing this right, an amendment regarding privacy should also protect one's right to be left alone.
This right was first introduced by Justices Brandeis and Warren in their 1898 Harvard Law Review. Later, in his dissent of the ruling of Public Utilities Commission v. Pollock, which upheld the constitutionality of radio broadcasts in public transit, Justice William Douglas asserted that the right to be left alone was the beginning of all freedom. The founding fathers molded our Constitution to address the abuses they suffered at the hands of Britain. Likewise, Americans today must carefully tailor our Constitution to address society's evolving conceptions of liberty. Thank you.
Wow. Thank you very much. Tim, would you like to go first?
Sure. How does Madison figure into this? You know, I mean, you've made the argument that the Anti-Federalists wanted structural as well as rights. So how does Madison figure into that struggle between those two agendas?
Madison was the one who ultimately crafted and proposed the amendments at one of the first Continental Congresses. He did have the ability to choose what structural changes and what rights were included in the amendments he brought to the table, thereby making it so that really not many anti-federalist goals were fully addressed at the first Congress.
Yeah. Well, so James Madison was a leader at the Philadelphia Convention, and while he denied George Mason's proposal of the Bill of Rights at the convention, he did promise to add a Bill of Rights later in order to secure the ratification from smaller states and those that were anti-federalist or were scared of the power the Constitution gave the centralized government. And so when he wrote the Bill of Rights, he wrote it more as a Federalist document in order to secure anti-federalist support rather than actually pleasing the anti-federalists.
Madison also had the support in both the Virginia Ratifying Convention and the first Congress after the ratification of the Constitution to push his agenda in both ratifying the Constitution in Virginia and putting down anti-federalist claims to propose more structural changes through amendments. And he was able to secure his Federalist-aligned amendments in the Bill of Rights due to his support in Congress.
So were anti-federalists, is it your contention anti-federalists are happy with the Bill of Rights?
I don't believe that anti-federalists were happy with the Bill of Rights at the time. An example of an amendment that they wanted to include but was ultimately denied by James Madison would be an amendment limiting Congress's ability to declare war in Article 1, Section 8, Clause 11. They wanted instead for 2/3 of state legislatures to have to give Congress the power to declare war. And because things such as this that did not structurally change the Constitution were not passed, I don't believe they would have been happy.
To disagree with my colleagues, some anti-federalists were supportive of the Bill of Rights and were pleased by the Bill of Rights. So for example, going again back to George Mason, who wrote the Virginia Declaration of Rights, which is very similar to the Federal Bill of Rights, George Mason was very happy with the rights-oriented restrictions on the federal government rather than the structural changes proposed by other smaller states like Massachusetts.
Thank you. Thank you. We'll move on.
Jack?
Do you think the anti-federalists would have been happier if Madison had put the word expressly in the 10th Amendment? So only confining Congress to powers expressly granted?
Yes, they would have greatly preferred that. Because they did not include the term expressly expressed in the Constitution, cases such as U.S. v. Comstock using the necessary and proper clause in Article 1, Section 8, Clause 18 have been able to expand government power and congressional power beyond the powers listed in Article 1, Section 8.
What's more, often many anti-federalists use somewhat of a buzzword phrase of not expressly when proposing changes to the Constitution, such as the 10th Amendment, which is similar to how the Federalists used the buzzword phrase of necessary and proper in regards to giving Congress enough power to execute its powers.
This is not to say that the 10th Amendment doesn't work as intended at all. The 10th Amendment allows states to act as laboratories of democracy, a term coined in New State Ice Company v. Liebman, and put forth legislation that might go against the federal government, but is still, but fits better for the people of that specific state. An example of us doing this in Washington state would be our legalization of death with dignity in RCW 7425.
All right, we have heard a number of cases. You obviously know your material. Is there a right about which you've been talking this morning that you as teenagers are afraid of losing, or is there a right you would like to see added that we don't have?
I would like a right to data privacy. Within the modern world, we have, as teenagers, we have been subjected to the world of technology, but have not been given the same protections as other rights. So for example, we as teenagers have, I'm sure, used social media before the age of 13, despite restrictions on social media. And so I would like to see legislation proposed at the federal level, similar to that of California's Consumer Protection Act, which protects the right of individuals to know which information corporations have on them, and even take that information back from the corporations themselves.
To elaborate on data privacy, while certain states such as Washington and California have proposed legislation like Washington's House Bill 1193, which bans warrantless data's use in the use of courts as evidence, I would say that because data is used almost worldwide, and your own personal data is used by companies worldwide, and the federal government itself too, with federal agencies such as the NSA, it is important to have protections at a federal level because data privacy is not confined to your own state.
That isn't to say that there isn't any precedent at all regarding online privacy or privacy regarding technology. In the Supreme Court case Riley v. California, there was a precedent set that unwarranted search and seizures of one's phone records is deemed unconstitutional.
Does it make let's talk a little bit about rights theory, not about rights specifically, but rights theory. In your mind, does it make a difference, the British theory of rights versus kind of this American theory of rights? Is that a big difference, or is that not a big difference?
I do believe there is a difference between the British system of rights and the American system of rights. The American system of rights focuses on writing our rights down and securing them through legislation and more securely in amendments and in the Constitution itself, whereas the British system relies on common law established through the ruling of William the Conqueror in 1066. And these systems differ because the enumeration of rights within the American system is much more secure, and our courts have to follow a system, whereas the common law system is a little bit more malleable and can vary depending on the specific right itself.
The reason that these systems are not the same, even though Americans immigrated over from Britain, is because while we did have some form of common law we brought over from the British, we do not have the hundreds and hundreds of years to look back to specifically within our own government, and hundreds and hundreds of years of precedent to look back on to uphold the laws that were valued so much so by the founders.
One of the most fundamental differences to me is the origin of rights themselves. In the British government, because the government is also the head of church and state, their rights come from both the government and from the government themselves, rather than possessing them innately. Following John Locke's theory of natural rights and American rights, they are held innately by the people, as expressed by Thomas Jefferson in his Declaration of Independence, that the purpose of government is to protect those rights, not to grant those natural rights.
Thank you.
So I'm curious. You said Americans came from Britain, but of course there were a lot of Americans who didn't come from Britain. In fact, there were a significant number of slaves in America in 1787. And the Constitution has specific protections for slavery in it, right? So To what extent do you think that the Bill of Rights is in tension with the original Constitution as a grant of rights, and yet the Constitution takes away rights?
The Constitution never explicitly defines the term people or the term citizens, or even uses the term citizens. However, notes in the Bill of Rights that the Bill of Rights protects the rights of the people. And so in this way, the founders left ambiguous which people they were actually protecting, and thus protected the institution of slavery. And then throughout history, the inequality that continues today.
One way that our Bill of Rights kind of creates tension between the Bill of Rights and the people and our Constitution and our government is by having our First Amendment, which allows us to protest and express our disapproval of the government when they are enacting or carrying out laws that we believe is against the people and ultimately does more harm than good. This can be seen in the civil rights movement, as many people believe, many African American people as well as white people believed that African Americans were not being treated justly under our government, and therefore exercised their rights to protest as a way to combat this.
Thank you.
Wow. Thank you all. I think one of the signs that we found over the years, one of the signs of a great conversation like this is when we have questions left and you have answers left. And I think that's where we are this morning. Gentlemen, would you like to give your feedback?
Go ahead, Jack.
Well, we talked yesterday. I'm still very impressed with the Chicago, Burlington, and Quincy Railroad. I love that, and it's actually not a very good case, but it's an interesting precedent. And you said something, and I was going to talk to you about it yesterday, and I forgot. You said Justice Brandeis and Justice Warren on the right of privacy, but it was actually in the 1890 article in Harvard Law Review. It was Samuel Warren, Brandeis's law partner, who never became a judge at all, who co-wrote that. Actually, he was the lead author, Warren and Brandeis. So just, don't assume that with similar names mean the same person. I like Jacobson. I'd be curious to talk more about medical freedom. I think that in the sort of core discussion that we are having about the framing and ratification of the Constitution and those first 10 amendments, I think you have a lot of knowledge. You know what you're talking about, and you know sort of the strategies that were involved, right? Madison was leading the effort to get amendments so that he could shut off anti-federalist opposition to the Constitution. And so I think that all came through very clearly. Again, I appreciate your knowledge. I appreciate your effort in putting this program, it's not really a program, this opening statement together. And yeah, I've been doing this for 2 days now. I have the rest of the day to go, and it's starting to show. I hope that you guys have the rest of the day off. So enjoy your day, and thank you for this discussion.
Thank you.
Okay, I'll go. Your opening statement was very thorough. I had got a chuckle out of using the corporate rights being incorporated amongst the first rather, we'll get to the personal rights later in the 20th century. I also thought your reference to Barron kind of as the roadblock, one of the early roadblocks to the Bill of Rights being real. I thought I was impressed with you in your 4 minutes. You laid out the argument that these anti-federalists are really concerned about structures as well as, and maybe even more importantly than just rights. So that's why I pushed you on Madison a little bit. What's his role? And you did a good job there. I would, if I was going to quibble a little bit in there, I would say my view of it might be that he's more interested in avoiding a second convention rather than securing ratification. Because by the time we get to even the Virginia Convention, they're real deep in the process, and many have already ratified the Constitution. So a little historical anachronism there. So the second convention, I think, would be something to consider. But I pushed you. Are anti-federalists happy? Heck no. And I mean, Grayson and Lee out of Virginia are livid. So yeah, and I think, I was intrigued by the use of buzzwords that the anti-federalists were prone to use expressly, and the federalists were prone to use necessary and proper. I like that idea. I've got to think about that a little bit. What are the buzzwords that are these political morsels that get tossed out? So I appreciate that. And I think that's an interesting configuration. So this has been a great 15 minutes. Thank you very much.
Thank
Thank
you.
you.
Do we have time for one or two more things? You're nodding at me. You're not.
Yes.
Okay.
Yes,
All right.
you have time.
We don't get to see you in Washington, and I would love to see you in person too. And I'm very jealous that you're going to get to go to the museums and all the things you're going to get to do today, and we didn't get to do that. I want you to know it makes me teary because I cry at the national anthem and everything else anyway, but it makes me emotional to realize that you guys know so much and all the potential that you have, and that our country is just going to be in great shape because you're going to be out there working in it. So it was just neat to hear you. You're real far away from me, but I understood every single thing you said, and our accents are not all that different. I really thought it was outstanding, and I was so impressed, and I was glad to get to hear you today.
All right, we'll give you a final applause for a job well done.